This video will help us understand how Brexit has impacted the constitutional principles of the UK by Ethan Garrett, Mark Sorokin, Harry Bryan and Thanassi. Brexit's impact on parliamentary sovereignty. Parliamentary sovereignty means that only Parliament can make statute law. Once made, this statute law can only be amended or abolished by Parliament, and no Parliament can limit a future Parliament. The EU Communities Act of 1972 meant that EU law became supreme law in the UK, as EU law is to be interpreted in line with UK law. Therefore, any new EU law automatically became statute law in the UK, undermining parliamentary sovereignty, as only Parliament can make statute law. In this case, the EU is creating statute law, while Parliament does not have to create any legislation to implement EU legislation. Therefore, by leaving the EU Communities Act is repealed, meaning UK law is no longer interpreted in line with EU law, as we are no longer members of the EU. Therefore, by leaving the EU, it means parliamentary sovereignty will no longer be undermined, as now only they can create statute law. Regarding human rights, by leaving the EU, the UK Parliament will have complete freedom over legislation regarding human rights. The Human Rights Act of 1998 made it so that any cases regarding the European Court of Human Rights can be taken to the English courts. It also meant all human rights protected by European Court of Human Rights had to be upheld. However, with Parliament once again becoming the only power that can legislate, it can amend this legislation. Obligations to the European Court of Human Rights may not change, but commitment might. This means certain human rights may not be protected in order to secure national security. Therefore, Brexit affects parliamentary sovereignty by making Parliament the only institution which can introduce legislature in the UK through the EU Withdrawal Act that took place at 11 PM on the 31st of January 2022, meaning the UK left the EU. Brexit's impact on the rule of law. The rule of law means that no one is above the law and that everyone must abide the law. On October 19, 2019, Boris Johnson requested a 3-month extension of the Brexit negotiations. The court told Boris that if he did this while simultaneously attempting to get the EU to reject it, he would be in contempt of them. This is ignoring legislation of Article 50, where only a 2-year period is allowed to discuss the leaving of a member of the EU. Therefore, Boris is breaking the rule by applying for a 3-month extension. The issue with this is that it showed that the rule of law did not apply to Boris Johnson. The checks and balances refer to the separation of powers in the UK. There is the executive being the government, the legislature being Parliament, and there is the judiciary being the courts. The separation of powers is to prevent autocracy. The prorogation of Parliament is a breach of the rule of law. It is law that the government, which is the executive, has to go through the legislature and the judiciary. In this case, the prorogation of Parliament meant that it disrupted Parliament's role as the legislature. This is a breach of law, as it meant that the government did not have to work through Parliament, therefore meaning that the rule of law was not abided to. Therefore, Brexit meant that the rule of law was not always abided to. Both the request of an extension in the negotiations of Brexit and the prorogation of Parliament breached the rule of law, as it did not apply to those who carried out these actions.
The term constitutional monarchy is defined as such: a form of monarchy in which the sovereign exercises authority in accordance to a written or an unwritten constitution. This particular principle is rarely brought up and discussed, precisely because it is normally left untouched. The monarch is there as a formality, while the democratically elected MPs are there to make the decisions, basically meaning that the Queen's job is to drink tea while staying out of politics, and Parliament's job is to pass legislation. Which is all the more reason why Boris getting the Queen involved raised some questions. On August 28th of 2019, the Parliament of the United Kingdom was ordered to be prorogued by Queen Elizabeth II, upon the advice of the Conservative Prime Minister Boris Johnson, advice that was later ruled to be unlawful. There are no rules regulating prorogation. Instead, the Prime Minister is expected to exercise restraint, and Boris took full advantage of that showing the need of reform regarding this part of the constitution. Although it might be thought that prorogation was ripe for constitutional reform, yet the Fixed Term Parliaments Act expressly left prorogation untouched. In the past few years, this has been questioned by the UCL Constitution Unit and myself on the simple proposition that it should be up to Parliament itself when its session begin and end, and not for the government to act through the monarch. It has to be added that Parliament should have never allowed Boris to organise such a mockery of the British Constitution, but as disappointing as it might be, it is also to be expected, due to the fact that the majority in Parliament are made up of compliant members who would allow the leader of the party to do whatever he or she desires, even if it's to shut down Parliament in order to make Brexit happen. One of the constitutional principles impacted most by Brexit is unitary state. Unitary state is defined as a state governed as a single entity, in which the central government is ultimately supreme. In this case, the central government is the good old Parliament in Westminster, London. This means that although Scotland, Wales and Northern Ireland have a degree of autonomy and devolved powers, the Scottish Parliament, for example, that power is nevertheless delegated by the Parliament of the United Kingdom, which may enact laws unilaterally altering or abolishing any changes Scotland, Wales, or Northern Ireland may have previously made. Underlying the amount of autonomy and independence these countries/regions actually have, which, for those to whom it isn't obvious, is very little. Brexit is a prime example of how unitary state in UK functions. Thankfully for the government in place, Wales seems relatively happy about Brexit, even though EU structural funding and farming subsidies will no longer be available to Wales, even under a soft Brexit scenario, which is important considering that overall Wales receives more EU funding per person than other UK countries combined, £628 to £368, and has around 40% of its exports that go to the EU. According to CEBR Centre of Economics and Business Research, around 200,000 jobs in Wales are directly or indirectly dependent on exporting to other EU countries. Perhaps Wales isn't in the headlines of the political section in the newspaper because they voted to leave the EU, or perhaps it's because the potential effects of Brexit are more to do with economics, meaning that they're just making headlines elsewhere. Or maybe it's because, as devastating as the effects might be, they are not as nearly as explicit and pressing as the issues Brexit brought to Northern Ireland and Scotland. In 2014, Scotland had a referendum in which, by a small margin, the people of Scotland decided to remain as a part of the UK, agreeing to work within a system that's in place now. However, in 2016, both Scotland and Northern Ireland voted to remain in the EU. An impossible task to achieve considering the fact that you can't possibly be both a part of the UK and the EU if the UK is out of the EU. Not a hard thing to figure out. However, the Parliament of the so-called autonomous country weren't asked when the Conservatives pushed through the Brexit deal. Underlying the supremacy of the centralised government, it's still unknown if the little autonomy Scotland has is enough to lead to an outcome the country wants. Under the Scotland Act of 1998, the Scottish Parliament is not allowed to pass legislation relating to matters of quote-unquote reserved to Westminster, including quote-unquote the Union of Kingdom of Scotland and England. This is widely interpreted to mean that any referendum relating to Scottish independence would require Westminster's approval. However, the matter has never been tested in court, so there remains some uncertainty about whether Scotland could hold an adversary referendum without consent. In 2012, the UK and Scottish governments signed the Edinburgh Agreement, which temporarily empowered the Scottish Parliament to hold the first independence referendum. This power was transferred using a so-called Section 30 order, which, quote-unquote, put beyond doubt the legality of the referendum. The Scottish government did not explicitly concede that a referendum could never be held without Westminster's authorization, but its preference is to proceed with an agreement, since any unauthorized referendum could be blocked in the Supreme Court or simply boycotted by the Unionist parties. The 2019 Labour manifesto said that it would not authorize a second referendum. And while the Scottish Government remains of the view that Scotland should be given a choice between Brexit and independence, In April 2019, Sturgeon said that voters should have an opportunity to make a decision on Scotland's future before the next Scottish parliamentary election, which is in 2021. But after the Brexit path has been determined, and to allow an informed choice to be made, Westminster doesn't really care about Scotland's feelings, and nor is it its job to do so. It's quite likely that Scotland will have another referendum, the outcome of which will probably be accepted by the UK's Parliament. But were that not to be the case, there is nothing in the Constitution stopping Parliament from not approving another referendum or rejecting its results, consequently forcing Scotland to stay. Which leads us to Northern Ireland, which, for one would think obvious reasons, also decided to remain in the EU. However it might be, being a politician in Westminster is hard, which is why we shouldn't judge them too harshly when they sometimes miss certain things when making decisions from which the future of the nation depends, even when that thing is an agreement that stopped a bloody 30-year-old lasting war. The Good Friday Agreement was outright ignored when accepting the contradicting deal with the EU. Among other things, it was mostly the part that stated the avoidance of a hard border, including any physical infrastructure or related checks and controls. Brexit accomplished all the opposite, and while the two situations between Northern Ireland and Scotland seem very different, Northern Ireland, even less so than Scotland, can't do much about the fact that it wants to remain in the EU. Brexit and an uncodified constitution allows Parliament to implement everything that it promised, including breaking one of the standing points of an agreement that could lead to civil unrest and reawakening a long-forgotten dormant conflict, which, in order to avoid, they would either need to back off from Brexit, which obviously isn't going to happen, granting Northern Ireland independence, which is not likely to happen either, or the most probable option of which, just to do something that will prevent the problem of having an immediate effect, and just to work on it when they cleaned up all the other mess they've caused. I think this is the perfect part to mention that I'm grateful that the task said, how does Brexit help us understand UK's constitution, and not how did Brexit show us that the UK's constitution works. In conclusion, through the two cases, Brexit shows us a couple of things. One, unitary state only allows so-called autonomous states to make decisions that don't have any real effect on the monarchy itself. They're allowed to pass legislation that Parliament doesn't care about. They're giving crumbs of power from the fat pie of intrinsic power in Westminster, which was previously discussed by Ethan. Parliament gets to do whatever it thinks is right. However, at the same time, it shows that sometimes those countries get to decide for themselves, not because they are constitutionally allowed to do so, but because Parliament isn't controlled by EU dictators, at least for now. Lastly, it shows the fact that no matter how weird politics might get, there is always a possibility for an unprecedented situation like such, and we just have to wait and see how the incredible pressure on the unitary state brought by contrasting votes would result in. Parliamentary government means that the government is chosen by, operates through, and is accountable to Parliament. Brexit showed us that even though that's how things should work, because our constitution is not rock solid, that it's not always the case. Because the Conservatives have the majority in Parliament, it's often the time that it's the party leaders making decisions and not Parliament. The European Union Future Relationship Act of 2020 was passed within hours just because Boris needed it done fast, giving MPs virtually no time to scrutinize what was arguably the most important act of the year. Brexit made an already existing issue crystal clear. As it is often said by Mr. Floyd, when government says to jump, Parliament asks how high. Normally it's not as visible to the general public, but the countless acts that the government had to do in order to make Brexit happen shows that although Parliament is in the driver's seat, the government, or in this case Boris Johnson, is the one telling them when to turn and what laws to pass.